Well, new at 5, we're talking with Clemson professor Dr. Kevin Vance. You've seen him quite a bit on here from Clemson.
And good afternoon, Dr. Vance. Thanks for joining us this Friday. We have a lot of questions about some developing stories from Capitol Hill this week. So let's start with Georgia Republican Representative Marjorie Greene Taylor. A lot of headlines with her. And just yesterday, the House voted to remove her from her committee assignments. What is the process of that and the severity of it?
Well, it's a big deal that the whole House has made this decision to take away her committee assignments. Traditionally, it was up to the leadership of both parties to sort of police their own members and control their own members' appointments to committees. There's nothing in the Constitution or in the law that gives specific requirements for how those assignments could or should be taken away, so it's really up to the party leaders. But in this case, it does set a new precedent of a majority taking away a committee assignment from a minority member, and so that might have implications for the future.
And Dr. Vance, I've been seeing this reported a lot. You know, she was voted by the voters there in Georgia to be going to Washington. A lot of these statements were made even before she was running. So can she be removed from office and just set a kind of a precedent? Because, I mean, a lot of these issues were, you know, out there and the people still voted for her.
Yeah, and those considerations you bring up are some of the same considerations that come out in these House and Senate debates when these issues are discussed. When the founders wrote the Constitution, they made a provision so that members could be expelled with a supermajority 2/3 vote. They didn't want to go with a simple majority because they were afraid it would be abused by majorities to just get rid of their political enemies if we were in a contentious political situation. So we have this supermajority vote. But in a democracy, it's always quite controversial because it's technically undemocratic in the sense that the voters have elected this person and they'd be deprived of representation if the person's expelled. And so it's a tool that's been rarely used since the Civil War. It's only been used twice, and in both cases it was used after someone had been convicted of a federal crime.
And Cody mentioned that precedent. Some lawmakers warning that removing her could create that risk for the future and what that looks like for other representatives. What would that precedent mean?
Yeah, by moving in that direction toward removal, I think it might lower the threshold that we've seen in the last two since the Civil War, which is wait for someone to be convicted of a federal crime. But that being said, the Constitution is open-ended about what the reasons could be for expelling a member. So it could be for committing a crime. It could be for really any political reason. It's a political process, and no federal court would ever intervene, I don't think, if one House of Congress were to use that 2/3 supermajority tool to expel a member. And so, you know, it'd set up a special election, and it would, you know, probably heighten partisan animosity, but it might, then again, it might take care of a problem for both parties.
And Dr. Vance, it seems like the Democrats have kind of tempted the former president, Donald Trump, to testify next week when that Senate trial starts on Tuesday. But he was quick to point out, or his team was, that he's not going to, at least right now. Can they force him to do this? And are you surprised that the president wouldn't show up and testify himself?
I'm not surprised, and I'm certainly not surprised that his lawyers have tried to protect their client by trying to keep him from testifying. But traditionally, presidents have claimed broad executive privilege to protect the documents that are connected to their presidency and to protect people that they spoke to as witnesses. And that executive privilege would be invoked in this case. It raises a whole bunch of murky constitutional interpretation questions like, do claims of executive privilege have any bearing on impeachment trials, as they would in a regular judicial proceeding in some cases? Could a former president claim executive privilege? Those are all things that will have to be worked out again between the parties themselves. It's a political process. I don't think the Supreme Court would ever involve itself in it. And actually, maybe President Biden could be a negotiator if it really got to this point, because the president has an incentive in protecting something connected to executive privilege himself.
And lastly, what can we expect on that first day of the impeachment proceedings? It's, you know, coming up fast next week already.
Well, if the last impeachment trial is any guide, there might actually be a lot of fireworks on the very first day or two, because that's when they're going to set and decide on the rules. So they'll both sides will debate the rules, and then hopefully there'll be some votes on what the rules are going to be. So we'll know hopefully about witnesses. We'll know about documents. We'll know about the timeline, and so we'll know how long it'll stretch and that kind of thing. So we should know a whole lot about the contours of the rest of the trial after that first day or two.
All right, well, Dr. Vance, we just got that notice from Fox News, 1 o'clock on Tuesdays when we're expecting for the Senate trial to start. So we might see you back here Tuesday afternoon and get your opinion on the day's events. So we appreciate it as always. Have a great weekend, and I'm sure we'll see you next week.
Thank you.
All right, you too.